I can confirm that this meeting is being held in accordance with the Licensing Act 2003 and the Licensing Act Hearing Regulations 2005, which allow councils to make their own arrangements for licensing subcommittees to hear matters in connection with premises licence. I will begin by introducing the subcommittee members and officers who will be present throughout the meeting. I'm the chair, Councillor Polly Andrews, and to my left we have Councillor Dave Davis and Councillor Peter Hamlin. To my right we have the legal advisor, Mr. Ben Davis. The clerk to the subcommittee is Ms. Jen Priest, and providing technical support is Joelle Higgins. Other attendees will be introduced at relevant stages of the meeting. Please note that item 6 on the agenda, concerning a premises licence for Hereford Premier Inn, has been withdrawn following an agreement between the applicant and responsible authorities. Please note the following points with regard to the conduct of this meeting. The Council is video and audio streaming this meeting live on the internet and making a recording. The recording forms part of the public record of the meeting and will be available on the Council's website. Please remember what you say and do in this meeting has a global reach, and your words and actions should be chosen carefully. Please ensure that all mobile devices are switched to silent. If any remote attendee loses connection, the meeting will be paused to ascertain if the connection can be restored quickly. If it is not possible to recover the connection within a reasonable amount of time, the meeting will continue. If you plan to leave before the end of the meeting, please can you indicate this in advance. Are there any questions about the procedure before we continue? No? Right. Therefore, thank you. I will now proceed with the formal agenda of the meeting. We have no apologies for absence? No. Are there any named substitutes? No. No. Right. Are there any interests to be declared for items on the agenda today? No. Thank you. Right, we'll move to the meat of the meeting. The application is for a grant of premises licence in respect of Ross Conservative Function Room, Hillsborough House, the Avenue, Ross-on-Wye, HR9 5AW, a Licensing Act 2003. The purpose is to consider an application for a grant for a premises licence in respect of the Ross Conservative Function Room, Hillsborough House, the Avenue, Ross-on-Wye. On behalf of the licensing authority, Mr. Fred Spriggs and Mrs. Emma Bowell, and in order of speakers, on behalf of the licensing authority, Emma Bowell and Fred Spriggs, public representations, Mr. Barry Williams. You can hear, can you, and see Mr. Williams? Thank you. And for the applicant, Dawn Griffiths, Laura Dobbs, and Adrian Jones. Order of speakers, number 1 will be Emma Bowell on behalf of the licensing authority, Barry Williams as local resident, Dawn Griffiths, Laura Dobbs and Adrian Jones, all on behalf of the Ross Conservative Function Room. There will be questions from the subcommittee members, and then we will adjourn to discuss our recommendation, and we'll let you know when to come back in. Are you all clear on the procedures? Thank you. Right, we will start. Emma, would you like to start?
Thank you, Chair. So the Chair rightfully said we're here today to consider an application for a grant of a premise licence in respect of Ross Conservative Club Function Room. The recommendations to the subcommittee are that it determines the application with a view to promote the licensing objectives in the overall interest of the local community. They should give appropriate weight to the steps that are appropriate to promote the licensing objectives, the representations, including supporting information presented by all parties, the guidance issued to local authorities under Section 182 of the Licensing Act 2003, and the Herefordshire Council Statement of Licensing Policy 2020 to 2025. And the reasons for those recommendations are it ensures compliance with the Licensing Act 2003. There are alternative options open to the subcommittee. One would be to grant the premise licence subject to conditions that are consistent with the operating schedule and accompanying the application. Grant the licence subject to modified conditions to that of the operating schedule. To exclude from the scope of the licence any licensable activities to which the application relates to. Refuse to specify a person in the licence as the premises supervisor or to refuse the application. The application for grant of a premise licence has received relevant representation and is therefore brought before the subcommittee today for determination. Heritage Council Statement of Licensing Policy 2020 to 2025 states all representation must be relevant. For example, they must be about the likely effect of the grant of the application. This follows paragraph 8.57 in the section 182 guidance and uses the same wording. The details of the application are: the applicant is Ross Conservative Club. We received the application on the 8th of August 2024. The 28-day consultation started on the 9th of August 24 and ended 28 days later on the 5th of September 24. The application can be found at Appendix 1 and requests a new premise licence for the function room at Ross Conservative Club. The Conservative Club already holds a club premise certificate, so this application relates to the function room only. The application seeks live music indoors, recorded music indoors, late night refreshment indoors and outdoors, and sale and supply of alcohol for consumption on and off the premises, Monday to Thursday 11 a.m. until 11 p.m. and Friday to Sunday 11 a.m. until half midnight. For reference, the club premise certificate allows the following: sale by retail of alcohol, supply of alcohol to members, indoor sporting events, Monday to Thursday 11 a.m. till 3 p.m. and 6 p.m. till 11 p.m. Friday and Saturday 11 a.m. till 3 p.m, 6 p.m. till half midnight. Sunday 11 a.m. till 3 p.m. and 6 p.m. till half 10. Performance of live music and any playing of recorded music Friday to Sunday 6 p.m. until half midnight. Summary of representations are: 3 representations were received from the responsible authorities, which are West Mercia Police, Training Standards and Environmental Protection. Conditions proposed by all responsible authorities have been agreed with the applicant and can be found at appendices 2, 3 and 4. 2 relevant representations have been received from members of the public, which the licensing authority have accepted as being relevant, and they can be found at Appendix 5. The applicant has engaged with the members of the public who raised representations and outlined their business model for the function room, and also shared a copy of the conditions agreed with the responsible authorities, and they can be found at Appendix 6. One member of the public has responded that they did not wish to withdraw their representation based on the additional information received by them. The licensing authority are yet to receive further correspondence from the other objector at the time the report was published. Any decision may have an impact on the local community. This report is in relation to a premises licence under the Licensing Act 2003, and as such there are minimal environmental impacts for the council. There are a number of equality duties and legal implications and resource implications found in this report that your legal advisor can advise on further, and there are unlikely to be any financial implications for the council as a licensing authority at this time. There is a right of appeal to Magistrates Court under Schedule 5 Part 1, which states: rejection of applications relating to a premise licence, where a licensing authority rejects an application for a premise licence under Section 18. The applicant may appeal against that decision. Under the same Schedule Part 1 Section 2 also states a decision to grant a premises licence. Again, your legal advisor can advise you on further. Any appeals should be made to Magistrates Court within 21 days, beginning with the day on which the appellant was notified by the licensing authority of the decision appealed against. There is little risk associated with the decision at this time, as the legislation allows that right of appeal to Magistrates Court within that 21 days. All responsible authorities and members of the public living within Herefordshire have been consulted, and appendices 1 to 6 are found at the back of this report. Thank you, Chair.
Thank you, Emma. Oh, excuse me. Now, Mr. Williams, I gather you're an objector if you would like to speak.
Yes, please, if I may. It's just that I live adjacent to the Conservative Club, and therefore any change to the licensing affects me directly. I have an apartment, a ground floor apartment with a patio, and my patio door is less than, well, it's about 10 to 20 meters from the function room. I am not an old person who objects to people having fun, and I don't have any problem with the current situation. But I believe that extending the hours is just an unnecessary burden on the people in the area. At the moment, when there is a function on at the Conservative Club, I cannot sit on my patio uh, because of the noise. And as I said, you know, people are entitled to have fun, and I don't object to that. But if you remove the respite between 3 p.m. and 6 p.m. in the afternoon, then you can say that the whole of the afternoon, or the time when I would be sitting on my patio, it has been removed. And not, as I say, the current situation is put upable, but not, but, you know, I don't object to that. If you extend the thing past midnight, um, then that's, again, I see no reason for that, because you can have as much fun up to 11:30 as you can from 11:30 till midnight. Also, the collateral damage, and I can't think of another sort of phrase to do that. People leaving the club, and this is not the problem, it's not the responsibility, or it's not nothing that they can do about it, but the collateral damage of people leaving goes on for at least an hour afterwards. People saying goodbye, people saying hello, people fighting, people having disagreements, etc., etc. And as I said, I am the closest to the area, and therefore am affected mostly. But there are at least 50 houses or residences within 100 meters of the premises, and so the noise after midnight would be, you know, considerable to many of those people. Um, and really, that is all. I don't have a problem with the actual staging of live music, recorded music, whatever. It is just the number of hours that it has been they are applying to have, and really that is the crux of my argument.
Thank you, Mr. Williams. Just for clarification, the hours are applied for are exactly the same as those existing, are they not, Emma?
On the club premise certificate, there is a gap between sort of the hours of 3 p.m. and 6 p.m. However, under the Live Music Act of 2012, you don't need to be licensed for live or recorded music for less than 500 people. It only comes in force at 11 p.m. at night, and any noise conditions aren't enforceable until that time either.
Right. Thank you, Mr. Williams.
Well, I merely mentioned it because you say in your introduction that it was that there was the gap, the timing was going from 3 p.m. until past midnight, whereas currently it's 3 p.m. until 6. Sorry, it's up until 3 p.m. and then from 6 till half midnight. As I said, I'm not objecting to the thing, but it's just to give us a break in our living.
Do you wish to ask Mr. Williams any questions?
No.
No?
No,
Right. Well, thank Dawn Griffiths. Is Dawn Griffiths there to speak? Are you? I think you're muted. Sorry, we can't hear you. Are you muted? Have you unmuted yourself?
If I can just interject, her picture. Oh no, there it is. Sorry.
Can you not? We can't hear you, I'm afraid.
Can you hear us now?
That's better, yes.
Sorry, we've been having issues.
Right, you're Dawn Griffiths, are you?
No, that's me.
Right, you're down to speak first, Dawn Griffiths.
Okay then. Thank you. Mr. Williams, you're saying about the noise levels. We haven't actually had any complaints from any of the neighbours next door or the surrounding area. The only noise complaint that we had, we did a Freedom of Information Act. Lord Dobbs did it in January 2011. There was an issue with an extractor fan. Other than that, we've had no complaints about the noise levels.
I said I am not complaining about the noise levels. I am accepting that people have got to have fun. All I am objecting is to the hours of the noise. And
Right, so
a break in the afternoon would be nice, so that I could sit on my patio and enjoy a little bit of peace and quiet. And after 11:30 at night, again, it would be nice to have a break rather than extending it till 12:30, especially on a Sunday or a Saturday and Friday, Saturday, and Sunday. Just seems a little bit, what's to be gained from the extra hour.
They already have permission to stay open. To the existing hours are as they are.
Yeah,
Right.
but on the application listed on their notice board, it said that it was extending till 12:30 from 11:30, and
well,
I'm just going on that.
No.
with regards to the actual application itself, it's so that we could open up to more members of our community, not just our members that we have for the club itself.
I'm not.
So
Please.
I'm not objecting to the licensing
But,
application
Miss-
per se. I am objecting to the hours of
Mr. Williams and Dawn, we are a licensing committee. Would you address your remarks to the committee, please? Not
Yeah.
have a debate between yourselves. Thank you. So have you anything else you wish to say, Dawn?
well, yes, obviously we've only had the one noise complaint. We're not making any changes to our hours at all. We just literally want to open up to other members of our community for them to be able to use our function room. We obviously had some issues with the other representation, apologies, Mrs. Burton obviously isn't with us today. We wanted to say, she said that there was disruptive behaviour from our clients at night. You'd said that there was fighting, Mr. Williams. We've never heard any fighting. We've never had to break up any fights. The majority of our clients are a lot older. We do occasionally have younger parties, but we've never had to break up any fights. So disruptive behaviour is probably just people saying goodbye, hello, etc. The other thing as well, Mrs. Burton had also complained about people using her car parking space. We find that quite odd. Reason being,
sorry, Mrs. Burton has not. We've not had any representations from this lady, have we?
We received another representation, but they aren't in attendance today.
Thank you. Okay.
it was literally just to address hers. I don't know if you take that into consideration if she's not here today, but there is an office building in between St Joseph's Apartments with a car parking space of 14 cars that they can get in the front car park with an additional 5 at the back. So we found it strange that someone was actually using her car parking space itself. I haven't got really anything more to add to it, really.
Much. And next one is Laura Dobbs.
Hi. Right, yeah, I just want to really put everyone's mind at rest. We're not changing anything to do with the opening hours. It will still only be till 3 p.m. in the day and then reopening at 6 p.m. at night. We've always had our club premises licence hours at 6 till 12:30 on a Friday and a Saturday evening. That's always been in place. Very rarely we have parties on a Friday evening anyway, and we're normally shut 11, if not just just after, because we normally have Skittles on a Friday night. So the only really late night that we would have would be if we got a function on a Saturday night. And again, we have it finished by 12, and then obviously people are leaving probably for the next hour. But nothing is changing regarding our opening hours at all.
Thank you. Any questions, committee? No?
Thank you.
No. Last one is Adrian Jones.
Good morning. Well, all I can do is illiterate what Laura and Dawn's already said. As they say, nothing's going to change much as far as the licensing is concerned. As far as I know, since I've been here in the 18 months, we've only received one phone call, which about noise, which was dealt with immediately, and people dispersed very quietly after that. So other than that, I don't think I can add anything to it.
Thank you. Committee, have you any further questions you would like to ask? Pardon? Our legal advisor would like to ask one question.
Just it's the position that your sort of operation is not going to change greatly, even if the license is granted. But just wonder, if you are to hold events in the function room to those people who aren't members, how will you engage with the sort of those members of the public who live in the immediate vicinity of the premises in light of those events, if there are going to be events? Will you be engaging with them?
Basically, we're in the middle of having like a new website done, and all it is to just help us bring in a little bit more revenue. So it gives us, we're able to advertise it for hire. So obviously that will be done through our website and our social media pages. But any function we have will be obviously private functions. We won't be having like a band, instance, a band on and just open free for all. It is literally just to open it up for hire so that people can have private functions.
Thank you. Thank you. And I can confirm that there's usually a member of staff, there's members of staff on premises at all times. So if there are any complaints, people can come and speak to you directly.
Absolutely.
Right.
Yeah, absolutely.
Thank you. Right.
Sorry, Chair, can I just confirm something with the committee? I think it might help all parties. So the noise conditions that have been agreed are noise or vibration shall not emanate from the premises as to cause a nuisance. All doors and windows at the premises shall be kept closed after 2300 hours except for immediate access and egress. Any speaker within the premises shall be directed away from any residential property, and prominent, clear and legible signage, no less than 32 font bold, shall be displayed at all exits to the premises, requesting the public to respect the needs of local residents and leave the premises quietly.
That seems extremely comprehensive. Thank you for that, making sure people are aware of those conditions. Thank you.
Chair, Madam Chairman,
Yes,
can I just make a comment, please?
just one comment there, Mr. Williams.
All right. It's just the fact that it says that the last information was that the speakers will be directed away from local residents. This property is in the middle of residents. There is no way, unless you pointed at the floor or at the ceiling, that the speakers can be pointed away from local residents. A minor thing, but
I am sure that the management will do their best to make sure that local residents are not.
As I said, it's just the extension. It's the time and the fact that there is no longer a gap in the middle of the day. Although it is said that they won't go continuously from the afternoon through to the evening. It doesn't mean that at some stage they change their mind and do so. That's all.
Thank you. We note your comment. Right, we will now adjourn the meeting to discuss our recommendation, what is the time? 25 past. We come back at, say, 1:45. Ah, he is. Thank you. I will now read you.
Chair, could we just please ask the stream to be started?
Is the live stream started now? Yes, sorry. Right, thank you for coming back. The decision of the subcommittee's decision is to approve the application as presented to the subcommittee today. The reasons: the subcommittee has taken into account the detailed representations and information presented at the hearing by the Senior Licensing Officer Emma Bowell, local resident Mr Barry Williams, and representatives of the applicant Ms Dawn Williams, Laura Dobbs and Adrian Jones to the hearing. The subcommittee fully recognises the concerns raised by Mr Williams and the reasons why the representations were made. The subcommittee can only consider those representations that relate to one or more of the licensing objectives. The subcommittee notes that there were representations were made by the Trading Standards Department, Environmental Protection and West Mercia Police seeking additional conditions on the licence which were accepted by the applicant. No further representations were received from the responsible authorities. The subcommittee notes that concerns have been raised by Mr Williams, who resides immediately adjacent to the premises, in relation to noise emanating from the venue, causing disturbance to local residents, potential for patrons of the premises causing disruption within the community, and the impact on the local area generally. The subcommittee notes that only one complaint has been identified by the applicant, and this dates back to 2011. No other formal complaints have been noted. The subcommittee notes the submission made by the applicant in support of the premises licence application, and also notes the conditions on the licence and the measures that are being taken to mitigate any potential impact on the local area. The subcommittee considers that the application made is comprehensive and will promote the licensing objectives. The subcommittee would strongly advise that should the premises licence conditions not be complied with, that the residents inform the management of the premises in the first instance, and if concerns continue, to inform Herefordshire Council, Environmental Health and Licensing Department, as well as other appropriate responsible authorities, so that concerns are properly documented as soon as practicable. Appeal information. Under Schedule 5, Paragraph 2 of the Licensing Act 2003, the applicant or person who made relevant representations may appeal against the decision. Schedule 5, Paragraph 9 states that such an appeal should be made in writing to the Magistrates Court within a period of 21 days, that the applicant is noted in writing of the decision. Should you wish to appeal this decision, then it is recommended that you obtain your own legal advice contact the Magistrates Court at Bath Street, Hereford. Thank you all for coming, and I will now close the meeting at 10 to 11. Yes, we will join. Thank you all very much. Stream is started. That stream is started. Thank you very much. Before I formally start the meeting, I will confirm that this meeting is being held in accordance with the Licensing Act 2003 and the Licensing Act Hearing Regulations 2005, which allow councils to make their own arrangements for the licensing subcommittees to hear matters in connection with premises licence. I will begin by introducing the subcommittee members and officers who will be present throughout the meeting. I am the chair, Councillor Polly Andrews. To my left is Councillor Dave Davies and Councillor Peter Hamlin. To my right is the legal advisor, Mr. Davies. The clerk to the subcommittee is Miss Jen Priest, and technical support Joelle Higgins. Please would you note that item 6 on the agenda concerning premises licence for Hereford Premier Inn has been withdrawn following an agreement between the applicant and the responsible authorities. Please note the following points with regard to the conduct of this meeting. The Council is video and audio streaming this meeting live on the internet and making a recording. The recording forms part of the public record of the meeting and will be available on the Council's website. Please remember that what you say and do in this meeting has a global reach, and your words and actions should be chosen carefully. Please ensure that all mobile devices are switched to silent. If any remote attendee loses connection, the meeting will be paused to ascertain if the connection can be restored quickly. If it is not possible to recover the connection within a reasonable amount of time, the meeting will continue. If you plan to leave before the end of the meeting, please can you indicate this in advance. Are there any questions, or do you all understand the? Yes, okay. Thank you. I will now proceed with the formal agenda of the meeting. Apologies for absence, none? No. No named substitutes? No. No, thank you. This is an application for the grant of a premises licence in respect of Flames, 59 Commercial Road, Hereford, appertaining to the Licensing Act 2003. In attendance for this application, we have present on behalf of the Licensing Authority, Emma Bowell and Mr. Fred Spriggs, PC Kirsty Norris, the West Mercia Police, Mr. Gabbage, who's the applicant, and the licensing guys, I think Mr. Semper, who is speaking on behalf of the licensing guys. Order of speakers, first will be Emma Bowell on behalf of the Licensing Authority, then PC Norris on behalf of West Mercia Police, the applicant Mr. Gabbage, and the licensing guys, the applicant's agent Mr. Semper. So we will now start. Emma, if you would like to start, please.
Thank you, Chair. As the Chair rightfully said, we're here today to consider an application for a grant of a premise licence in respect of Flames, 59A Commercial Road, Hereford. The recommendations are that the subcommittee determine the application with a view to promote the licensing objectives in the overall interests of the local community. They should give appropriate weight to the steps that are appropriate to promote those licensing objectives, the representations, including supporting information presented by all parties, the guidance issued to local authorities under Section 182 of the Licensing Act 2003, and the Herefordshire Council Statement of Licensing Policy 2020 to 2025. And the reasons for these recommendations are it ensures compliance with the Licensing Act 2003. There are a number of options open to the subcommittee today. One would be grant the licence subject to conditions that are consistent with the operating schedule. B, grant the licence subject to modified conditions to that of the operating schedule. C, to exclude from the scope of the licence any of the licensable activities to which the application relates. D, refuse to specify a person in the licence of the premises supervisor, which is not applicable in this case, or to refuse the application. The application for grant of a premise licence has received relevant representation and is therefore brought before the subcommittee for determination. Herefordshire Council Statement of Licensing Policy 2020 to 2025 states all representations must be relevant. For example, they must be about the likely effect of the grant of the application, and this is followed by paragraph 8.57 in the section 182 guidance, which uses the same wording. So the application details are as follows. The applicant is Flames Hereford Limited, the agent is the licensing guys, We received the application on the 30th of July 24. The 28-day consultation started on the 31st of July 24 and ended 28 days later on the 27th of August 24. The application, which can be found at Appendix 1, and requests the grant of a premise licence to allow the following licensable activities. Late night refreshment, indoors and outdoors, Monday to Sunday, 11 p.m. until 03:30. The applicant has also offered a set of conditions to promote the 4 licensing objectives, and these can be found at Appendix 2. And just so the committee are aware, which you probably already are, that late night refreshment is only applicable in a licensable activity Monday to Sunday, 11 p.m. until 5 a.m. One objection was received from West Mercia Police as a responsible authority, which stated West Mercia Police are willing to negotiate with the applicant over a terminal hour. That can be found at Appendix 3. An agreement has not taken place at the time of the report being published. Just a brief history of the premises. The previous premises licence under the name of Munchies was revoked by the licensing subcommittee on the 21st of February 24, following an application to review a premises licence received from West Mercia Police on the 5th of January 24 on the grounds of crime and disorder. The application put before you today states this is an entirely new operator in possession of a new lease drafted by MFG Solicitors of Telford and signed and dated on the 1st of July. There is no connection between the previous operator and the new business, and the application mirrors the operating schedule to which applied for before and operated between May 13 and February 24. A copy of the revoked licence can be found at Appendix 4 for information purposes only. Any decision may have an impact on the local community, and this report is in relation to a premises licence under the Licensing Act 2003, and as such there are minimal environmental impacts for the council. Equality, duty and legal implications are set out in this report, which your legal advisor can advise you on further if needed. There are unlikely to be any financial implications for the council as a licensing authority at this time. There is a right of appeal to Magistrates Court under Schedule 5 Part 1. Appeal should be made to the Magistrates Court and must be made within 21 days beginning with the day on which the appellant was notified by the licensing authority of the decision appealed against. There is little risk associated with the decision at this time, as the legislation allows for that right of appeal to Magistrates Court. All responsible authorities and members of the public living within Herefordshire have been consulted. Appendices 1 to 4 found at the back of this report, and since the report has been published, there have been 3 supplements published in addition. Thank you, Chair.
Thank you. Thank you, Ebba. We will now go to PC Kirsty Norris on behalf of the West Mercia.
Good morning. Can everybody hear me okay?
We can, thank you.
Excellent. First, I just want to apologise. We have got some dog training going on here, so if you can hear barking, that's what it is. So hopefully that should be done soon and not cause too much disruption. So I've just taken over from my colleague who put the initial objection in. So please forgive me if I read from my crib sheet just so I can remember what we're sort of going to go through. So an objection was raised by the representative of West Mercia Police with regards to a new application that has been submitted for a premises to be known as Flames. The reason for this is it was felt that the premises attracted considerable disorder during the nighttime economy setting due to its late night opening hours. The premises, previously known as Munchies, has previously been taken to a review and had its licence revoked due to the serious disorder that was connected to this premises. The licence was revoked in February 2024. The disorder connected to this review happened on the 15th of December 2023 at 04:45 hours, on the 29th of December 2023 at 10 to 1 in the morning, on the 14th/15th of January 2024, where the premises were seen still to be open at 4:10 in the morning, which is a breach of their licence conditions. Since the revocation of the late night licence, there's been a significant drop in disorder connected with this premises and in the area itself. However, there have still been 2 incidents of disorder connected with this premises, which infers that there are still issues here. Both of these incidents have happened before 10 p.m, one on the 2nd of the 3rd, 24, and one on the 10th of the 2nd, 24. If the premises is suffering from disorder this early on, which the staff can clearly not deal with, how are they expected to control any disorder when there were more people and potentially more intoxicated people there? While the poor running of the premises previously can be partially blamed for some of the disorder, The type of premises itself is not changing, so it is felt that this will attract the same people who cause the same issues regardless of who is running or owning the premises. This is a license for the premises, not for the applicant. The new license states that they are happy to have SIA door staff on the premises from midnight. There were door staff on the previous premises which did not prevent the disorder, and on some occasions actually added to the disorder along with staff working there. How can the new premises demonstrate that there will be any difference with them? What other conditions can they put in place to ensure this situation doesn't happen again? The owner or management of this may have changed, but have the staff changed? Or have the staff been retained from the previous management? This is not mentioned. How the premises are going to deal with poor behaviour of their staff members and what precautions are taken to ensure bad practice is not carried over under new management has not been addressed. There is nothing in the new licence application to show how they are intending to deal with any future issues, disorder or anything else. They were SIA previously, but still a great amount of serious disorder. So what plans by the new owner are there to deal with this? The new application is exactly the same as the old licence that was revoked. So how are they planning on addressing anything? The applicant and the agent have not put forward anything in addition. This is a previously known problem premises. So what changes are going to be made to prevent it from staying a problem premises? The new licence application gives no indication of future business model or how they plan to improve it. It is felt that this premises is unable to control the level of disorder associated with it, and granting it a late night licence would prove detrimental for the nighttime economy, the premises itself, members of the public and the local community, and the emergency services having to attend these incidents. I cannot see what other conditions can be applied to make the premises safe and a well-run premises. All the conditions were previously applied and did not work. Therefore, the only reasonable conclusion is that this licence must not be granted. You should note that once again the same conditions were on the revoked licence that are being offered on the new application. However, if the committee are minded to grant an application, the police have a number of conditions they would seek to be placed on the licence in an attempt to promote the licence and objectives, specifically that of the prevention of crime and disorder. The first one would be that all staff employed at the premises, whether paid or unpaid, are to be trained in conflict management resolution within 1 month of commencing employment at the premises. All staff training will be retrained every 6 months, and training records shall be kept on the premises and produced to any authorised person as defined in Section 13 of the Licensing Act 2003 on demand. I believe this has been discussed with the applicant and they were happy to have that sort of training in place. I have previously offered 2 alternatives to the applicant, which involve finishing at either 1:30 or 3:30, which would require either 2 or 4 SIA door staff to be present. However, I am willing to offer the following suggestions to the committee for consideration. This is the premises licence holder will ensure that a minimum of 3 SIA registered door supervisors will be employed at the premises on a Thursday, Friday, Saturday and Sunday before a bank holiday Monday, on Christmas Eve and New Year's Eve, and on the evenings preceding all other bank holidays from 11 p.m. until the end of the licensable activities. When employed, external door staff shall wear high-vis reflective jackets or vests, and when employed internally, they shall be readily available for those door staff. At all other times, the premises licence holder or person nominated by them in writing for the purpose will employ an SIA door staff risk assessment basis. The risk assessment shall be in writing and shall be made immediately available on request to an authorised person or to the police. The premises licence holder, DPS, or person nominated by them in writing for the purpose shall maintain a record and a register of door supervisors, which shall be kept on the premises, showing the names and addresses of the door supervisors, their badge numbers, and shall be signed by the door supervisors as they commence and conclude their duty. The register shall be made available on demand for inspection by any authorised person or police or an authorised officer of the SIA. The previous offer that I suggested which was not agreed. Had 2 separate finishing times. If the chair would like me to go over that, I'm more than happy to do that.
I think you suggested that either 1:30 or 3:30. Was that right?
Yes, that's correct, Chair. The 1:30 finish, we said we would be happy with 2 door staff, but the 3:30 finish we were requesting 4 door staff because of the level of disorder. However, as I've just gone over with that first initial proposal, I'm happy to use 3 door staff with those other conditions attached to it.
Thank you, PC Noakes. Could I? We will all send a copy of the police attendances. Very comprehensive it was too. But how can you be sure that all the disturbances emanated from this premises? Because Commercial Road is full of pubs and restaurants, so that people come in and out of. So you're convinced that all the disturbances emanated from this one particular premises?
So, Chair, with regards to our computer systems, what I submitted was some paperwork from a system we have called Innkeeper, which is where we register all the licensed premises in our force, and we log against them the incidents that happened at that specific premises. So with regards to the 2 call logs that I've submitted, they would then be uploaded onto Innkeeper by the officers to tell us what's happened, because sometimes on a log it doesn't always get updated. So they would put, this has happened at Munches, or this has happened at is it Mr. Chips? There's other ones up there, isn't there? So they would put, this has happened at this, or they would give an account of where it's happened and where they've had the problems. On the paperwork I submitted, which has got at the top of the form, Munches new premises application for flames, that is the print off of our Innkeeper system for the old Munches premises, and it shows on there at the bottom incidents, and then it shows the incidents that we've referenced that were used for the original revoke. There were other ones, but obviously that would have been used previously, so I don't think it was worth me going back that far. And then it would sort of say about any issues. There's visits that I've copied onto there, and it would say what issues they've had or haven't had with that premises. And it also shows about the issues and incidents that they've had since that license has been revoked. So that's, I'm not saying that other premises haven't got disorder, because all nighttime economy premises at some point do have disorder, and we would be silly to think that they don't. However, the amount of incidents linked to this are more than the other ones, and no other licenses have had to be revoked because of the disorder attached to them.
Thank you for that clarification. Committee members, have you, Councillor?
We've just heard in quite some detail a proposal with conditions attached to it, also in quite some detail. The one which started off with 3 SIA doormen, high-vis jackets, and a variety of other things that you mentioned afterwards. If we were minded to adopt that as a plan, do we have it somewhere in writing on any of these documents that we can look at it and review it when we're making our decision?
I can provide that for you if you need me to. It's not a problem.
I mean, like now, is it available anywhere? Because it didn't sound a bad plan as a possible way of moving forward with this one.
I can send an email over to anybody now if you want me to, with those extra conditions on for you to look at. It's not a problem.
I think if it's sent to the licensing address, Chair, then that can be shared with the parties in attendance at this hearing for transparency purposes.
Thank you. That's good.
Sorry,
Yep.
the Hereford licensing email.
Yes, please.
Okay, I can do that. No problem.
Have you any other, Councillor Davis? No. Councillor Hamlin, anything more? You?
No, that was my main point.
That was your main thing. Oh, thank you very much, PC Noakes. That was.
Chair, may I ask
Yes, you may.
Just it's just expanding on the point the chair raised. Just with the logs, just so we're able to read them correctly. Just the two sort of logs which detail the various actions from the police and officers at the time of the incidents, before the two incidents, I think in March and July of 24. Where it's just, can we pinpoint that it is Munchies that's the origin of the incidents? Is there anyone on the papers we can see that? Please.
Sorry, if you look onto the paperwork, that at the top of the sheet has premises 1069-7. If you go down to where it says incidents, which is on the first page, that details the premises issues before, and then at halfway down on the second page, you have got a dated incident 2nd of the 3rd 2024, and then a dated incident 10th of the 7th, and those are both submitted by officers that attended these incidents or dealt with these incidents. Does that make sense? I know always sometimes the logs that come off our call screen aren't that clear.
Looking at the PC notes, it doesn't specifically say Munchies, not on mine anyway.
No, so on the front page, that's what's printed off from the main screen of that premises. So if it was another premises, it would have a separate name on the front page. So what you're looking at there, I think, is the logs that come off.
That one.
Yeah. Sorry.
Thank you for that
I think that's where the confusion's come from, because we've got additional supplement, I think, which actually details
So I
the
provided
individual logs.
The TARB logs, yes, which are attached to those innkeeper inputs. And I've attached them just so they can see what the logs are showing, because they are quite confusing sometimes, the original logs that the chair is looking at, which is why the innkeeper printout's been provided, just to give that clarity.
May I ask a question of the officer, please, Chair?
Yes, you may.
Hi, Kirsty. It's Nick here from the licensing guys. Okay, just on dealing with that document you have in front of you, the innkeeper printout. I'm very familiar with this because I was one of the guys that implemented the WPC software package innkeeper when I was serving. If you look at page 4, the two incidents you've highlighted, can you see that the incident type's crime or disorder, and then they're subcategorized, please, as positive crime or disorder? Can we just confirm that, because I'll be referring to that in my presentation?
Yes, we can. Just for the chair, positive crime and disorder means that the premises have requested that sort of support, rather than it being called in by a member of the public. So yes, they are requesting help. However, it still shows that there's disorder at this premises.
I'm going to question that, because as certainly what was implemented when I was serving, positive means that there is no detriment to the person that reported it. Say, for example, a purse was stolen in a nightclub and the club reported that and handled it properly, then that would be recorded as a positive crime or disorder incident, in as much that none of the licensing objectives were offended, if you know what I mean, by the conduct of the premises license holder. I don't know if you want. I don't know if you want to come in on that, Kirsty.
Yeah. So with regards to that, obviously, I'm not sure how long you've not been in the force for, but obviously things have changed. So when it says positive crime and disorder, that is showing us that the premises are asking for help and trying to do something positive to deal with it. It's got nothing to do with how it affects the license and objectives.
Okay.
Thank
I'm
you.
going to challenge that. I'm going to challenge that, but maybe at another forum. So thank you very much indeed. Thank you for that clarity.
Thank you. PC Noakes? No? No.
Sorry, Chair, I didn't hear you.
Have you anything more to add?
No, I haven't. Sorry.
Right,
Apologies,
thank you.
were frozen. Sorry.
Right, can we move on to the next speaker, Mr. Gabbage, who is the applicant. Mr. Gabbage, can you hear us?
That'll be me, ma'am. I'm presenting on behalf of Mr. Gabbage.
Right, and that say your bit.
Okay, thank you. Well, I am Nick Semper from the licensing guys, and we're representing the applicant here today, being Flames Limited, Hereford Limited, and here represented by Mohammed Gabbage and Vicky Powers, who is his life partner, is going to help with any technical sort of language around licensing. So this is a fast food outlet formerly known as Munchies, now rebranded as Flames. By way of background, under the previous operator, the previous premises license, that's PRO 1581, for Munchies, it was issued in May 2013. Now, I distinctly remember this because I was representing the police on that occasion, and at the hearing, the licensing committee agreed that the premises should be conditioned so as to have 2 SIA staff on duty for midnight over weekends. Now, this previous licence was indeed reviewed as a result of an incident that occurred on the 15th of December 2003 following a disorder which included associates of the former business and issues with the performance of the SIA door staff. Now, that licence was subsequently revoked in February 2024, and fair enough, we'd all agree on that. But this is an entirely new operator in possession, I should say, of a new lease drafted by MFG solicitors in Telford, signed and dated 1st of July 2024. There is simply no connection between the previous operator and the new business. This application is a mirror application with regards to the operating schedule to that which applied before, and operated with, and that this previous operating schedule, according to my information and the information that's been placed before you today, operated without issue between May 2013 and December 2023. And clearly there's no sale of alcohol or regulated entertainment entailed in this application whatsoever. Now, as you'll be aware, each application must be judged on its own facts and merits. The significant merits of this application is that it is a reapplication for a premises license which operated correctly for over a decade until the event which precipitated the revocation. That event had absolutely nothing to do with the current applicant. This is a de novo application, and that which went on before has nothing to do with this applicant and cannot stand to his detriment to the slightest degree. Now, in this hearing, the burden is on the applicant, i.e. me and Mr. Gabbage, to show that the proposed operation, supported by the proposed operating schedule, is capable of promoting the licensing objectives and is unlikely to undermine them. Any representatives here, the police opposing, have the burden to show that these premises, operating under the operating schedule before you, will undermine the licensing objectives and demonstrate that with evidence. In our submission, any subcommittee properly advised can only refuse this application if it is found on the evidence of the representatives to be not capable of promoting the licensing objectives. So you may ask yourself, why do we need evidence? Why do representatives and objectors need to produce evidence? Well, the answer is found in para 9.43, the section 182 guidance, which clearly states, and I quote, the authority's determination, i.e. your decision, should be evidence-based, just as being justified as being appropriate for the promotion of the licensing objectives and proportionate as to what it is intended to achieve. Now, significantly, there's not a shred of empirical evidence in the comprehensive hearing papers today which challenges, criticises, or for the most part references the operating schedule or this applicant whatsoever. That's an undeniable fact. Now, we've heard some further information today and a revisit on the conditions, and we'll go to those in a minute. So the only party who have objected is the police. And firstly, PC Wall, the predecessor for PC Norris, filed a representation. It stated that the premises had been required to, since the premises had been required to close at 11 o'clock each night, there had been a decrease in disorder in and around the premises, but they were willing to negotiate with us on an earlier terminal hour. Now, from that date, we wrote repeatedly to the police to enable that discussion. And because of this internal restructuring we've heard about, we were unable to elicit a reply or response to our freedom of information requests. And that response to the FOI has been so delayed that it's not here before us today, so it can't be put before the hearing. So in dealing with the first aspect, we observed that during the same time period, okay, so what he's saying is, since it's closed, there's been a reduction of crime disorder. Right, okay. Right, well, during the same time period, Associate's been closed. This is a very large licensed premises a little further down Commercial Road. And with respect, I don't think the police can simply ascribe a reduction in crime disorder solely to the earlier closing of these premises, when at the same time a major operator nearby has also been closed, resulting in much less footfall and much less consumption of alcohol in the area. Furthermore, Munchies has been closed for weeks due to it being undergoing a major refurbishment at the moment as it transforms into Flames. It's not even open. So the premises is simply not open. So there must necessarily be a reduction in incidents there as it is closed. So there's actually no evidence to support the reduction theory. And frankly, the crime disorder stats for the city centre, if you look on the Home Office website, it's called Crime Mapper, they've remained static during this period. So we recently established contact with PC Norris, and we're very pleased that she's in office, and we're pleased to see her here today. So welcome to you. Now, unlike her predecessor, PC Wall, PC Norris didn't want a reduction in hours when she engaged with us. Instead, she wanted us to accept conditions, and the first one is that all staff to be conflict management trained, staff records to be kept on site and available for viewing on request. We accept that. That's a really good idea. So thank you for that, PC Norris. But she also wanted us to stay open till 1:30 with 2 SIA door staff present during every night of the week on the face of the paperwork she sent to us. Clearly, we think that's disproportionate. It should be Fridays and Saturdays, bank holidays and what have you. And furthermore, she wanted a further 2 door staff on from 1:30 till 3:30, which is the terminal hour, making it 4 SIA staff in a premises that only has 2 members of staff anyway. So there'd be 4 SIA guarding 2 members of staff as they work serving fast food to the nighttime economy. So to support the imposition of these new conditions, the cost of which would be £20 an hour per SIA member of staff, this would bankrupt the business, and we'll do the figures in a minute. But to support this proposition that she came up with, she cited 2 incidents recorded on the police systems. The first happened at 21:05 on the 2nd of March. Staff called the police to say that a customer wanted to fight with them. On attendance, the male had already left the shop, so we never got to the bottom of that. And secondly, at about 8 o'clock on the 10th of July, the passing police arrested a drunken man who kicked the shop window from outside. It wasn't a customer. On passing, it was the night of the England-Holland football match. I don't know why he upset, because we won that one. But he went and kicked their window, and a conversation ensued. Heated due to the state of the guy, and the police arrested him for being drunk and disorderly and for criminal damage and took him away. So we can conclude from these incidents in my submission that, right, the first incident took place 4 months before this applicant took on the lease of Munchies, and therefore cannot be anything to do with him for the same reasons. He cannot be held responsible for the circumstances which led up to the revocation of this licence back in February 2024. Here, a customer was threatening to fight them, and they called the police, which is absolutely the right thing to do. Secondly, the second incident occurred on that football night, and a guy came by. It wasn't a customer, tried to kick a window through. Staff called the police, who were in attendance, and things took their course from there. Now, both these incidents are recorded on the innkeeper system, which is shown on that page 4 we were just discussing. This, and I've been retired for a few years, but I'm really going to have to question the explanation you've been given, because that system allows incidents to be categorised, and both were categorised as positive crime disorder. Now, certainly in my time, and again, I'm going to have to make some inquiries, this category refers to incidents that have occurred at or near individual premises, but where no criticism is made to the management of those premises. Therefore, neither incident speak to the detriment of the premises or the applicant themselves, because they are positive. Okay. So the fourth issue is with respect. It's not that the premises has been named in the incident that actually matters. The only consideration to this committee, in my respectful submission, is it should be whether the operator has undermined or failed to promote the licensing objectives in the handling of those 2 issues, one of which happened 4 months before the applicant ever took over the premises. So I gave an example before where a premises could be the location for the theft of a purse, and it doesn't mean that the premises license is responsible for that theft or liable in some way for that incident. All that matters in this hearing, in our submission, is whether the operators fail to maintain good standards as defined by the Licensing Act, or can be shown by the evidence that they were likely to undermine them. So in both these cases, this is the fifth reason that we're going to talk about the victim charter very briefly or very obliquely. Staff from the premises were reported being victims of crime and aggression. Somehow we've managed to turn their legitimate requests for assistance from the police into a rod to beat them with, in supposing that they are in some way responsible for them being the victims of crime, and that consequently they must be required to have 4 SIA staff on duty in a small fast food outlet that employs only 2 members of staff. So that's actually sort of verging on victim blaming, as unlike the previous operator who failed to promote the licensing objective, this applicant has done absolutely nothing wrong. So the 6th reason is this: both incidents occurred in the early evening. Okay, as you're aware, no licensable activities were taking place at the premises whatsoever at the time of these 2 incidents cited, as late night refreshment does not become a licensable activity until 2300 hours. So I venture to suggest that the time parameters makes those incident an irrelevant consideration to what we're discussing today, which is the provision of late night refreshment after 11 o'clock at night. Okay, now the next one is that by comparison, let's have a look at what else is going on that street. And Chair, you very rightly, well, in fact, everybody mentioned the fact there's other stuff going on down there. Perfect Pizza is nearby. It's open every day until 1:30 with no security. Marmaris is open until 3 a.m. and 4:30 at the weekends without security. Sizzlers is open till 3:30 weekends, no security. Mr. Chips is open till 3:30 at weekends with 1 SIA, and Golden Galleon is open till 4:30 with only 2 SIA. So I failed to understand why there needs to be 4. It's been dialed down to 3, but why there needs to be additional provision to do with this place when anything that went on in the past is nothing to do with this applicant and therefore this application. And the conservative cost of employing this SIA element, to the extent that the police require, is £20 per hour. It's £20 per hour per member of staff. SIA, that's £200 a night. So that's the best part of £1,000 per working week. Now, para 1.17 of the statutory guidance states that, and I quote again, sorry to do it, but it is the law, we're not said and done, or certainly the Secretary of State's guidance. 1.17 states that it is essential to avoid the imposition of disproportionate and overly burdensome conditions on premises where there is no need. Furthermore, para 9.44 states that the licensing authority, i.e. yourself, and quoting again, should aim to consider the potential burden that any condition would impose on the premises license holder, such as the financial burden. That's what the guidance is telling us. So my final point is that there's no need for such an imposition because it's disproportionate, and the evidence before you since that revocation simply does not require it or justify that expense. Now, lastly, as always, because I mean, it's even mentioned in the papers, the hearing bundle before you, but I've got to touch on it in case it needs to be brought up further upstream. I've got to talk to you about fear and speculation. And the police speculate that were you to grant this license, that there may be problems. Okay, there are 2 main reasons why fear and speculation are not admissible in these proceedings. Para 9.43 of the Section 182 guidance clearly states that your decision must be evidence-based. Fearing and speculating about what might or might not happen under this new operator at some undisclosed point in the future, and as a consequence of any decision today, is plainly not evidence. It is what it is. It is fearing and speculating about things that might go wrong in the future. Okay. And secondly, there's the ruling in the Daniel Thwaite and Wirral Borough Magistrates Court, the case of the High Court Justice in 2008, which again is referenced in your hearing bundle, helpfully by your licensing officers. And in that judgment handed down by Her Honour Justice Black, she stated that your decision making should be actuated by proper and real evidence. There is no history of problems with this applicant or his management of these premises, or the potential for any such issues and the potential for any more such issues is more than amply addressed in the proposed conditions. And in any event, were there to be problems further upstream, then Parliament, the Licensing Act has already provided a mechanism to deal with those problems, and that, of course, is a Section 51 review, which is the very mechanism you're not scared to employ because you employed it back in February against the previous operator. So were you to grant this license and were problems to ensue, then the legal, lawful and proportionate mechanism to control them is self-evidently provided through the aforementioned Section 51 process, review process, were problems to occur in the future. So look, this hearing is simply about whether this brand new operator, against whom you have heard nothing to his detriment, operating his small fast food outlets, operating these hours in accordance with the operating schedule, which is operated from 2013 to 2024 without issue, including a comprehensive raft of conditions and the additional condition to do with conflict management, conflict management training. We accept that. That's a good idea. Whether this premises will undermine or whether it will promote the licensing objectives. Now, very clearly, our position is that it will not undermine them. There is no indelible evidence of current risks to public safety or crime disorder, or indeed any other cause for concern regarding the promotion of licensing objectives evidenced involving this application or this applicant before you. Of the 2 incidents cited against him, one occurred 4 months before he took over, and both of them show staff at the premises actually to be the victims of crime. That, again, is an undeniable and self-evident fact. So consequently, I respectfully request that you do indeed grant this application for the premises licenses sought to get them back up and running and serving a nighttime economy as they have been since 2013. But under a new manager, the whole place has been gutted. It's been made out. You've got the new applicant, the new business owners in front of you there. And in doing so, you grant this license and you wish Mohammed every ongoing success with this established but now completely refurbished fast food enterprise. Thank you very much indeed. Thank you.
Thank you, Mr. Semper. Excuse me, I'm losing a voice here. As you are aware from PC Norris, I take it that the applicant wants to finish at 3:30, not 1:30. Am I correct?
Yeah, 3:30, please, ma'am. Yes.
3:30, and as you say, the police are very anxious about the number of SIA door people. You say that 4 is excessive. The police are asking for 3. What are the views on that?
We believe that 2 is appropriate. Is appropriate, ma'am, and there is a considerable cost. There is in the original correspondence we had from Kirsty, which only landed a couple of days ago. It looked like she wanted them every day of the week. I think we can benefit from some clarity about whether she's talking about Fridays, Saturdays, Sundays before bank holidays and bank holidays, and to start at midnight as well. That wasn't specified in the correspondence, but we've taken that as read.
Right. Thank you. Committee, Mr. Councillor Davis, Councillor Hamlin.
Yeah, please, Chair.
Councillor Davis.
Thank you, Chair. Mr. Semper, can you clarify? I understand this is obviously a new business, a new venture with new owners and control. Obviously, we're looking at the licence of the premises, which has had issues previously. Can you confirm the staff? Will they be the same staff members as previously, or are they going to be a complete new set of staff members, including the SIA store staff? Thank you.
Yeah. Yes. Right. Okay. It will be new staff. We've got Corrie working down there now. Completely new staff when they reopen, and the SIA is being sought from the same team that provide the SIA to the Golden Galleon. You're nodding away there, Vicky. Can you just come in on that, please?
Hi there. Can you hear me okay?
Yeah, you're going to have to shout.
Okay. Sorry. My son, he currently works with Flames. We are looking at all new staff. We haven't started recruitment due to the fact that the refurbishment is going to be taking another month, maybe 2 months, because obviously we're completely revamping. All new door security. My partner has been speaking to other security teams that work in the street, and Golden Galleon's team, they have said that they can provide us with 2 new door security.
Thank you for that, Vicky.
Thank you.
Sir, has that answered your question?
I suppose the other part of the question is, when in the past two SIA door staff were insufficient, how do you believe that 2 staff will now be sufficient to deal with those circumstances that arise?
So we can't relitigate what happened before, okay? But my understanding of it was there was a fallout between staff working at the premises in the last business, okay? And the SIA stood by and did nothing when they should have had a positive duty to act. Okay, so it wasn't a question of the SIA ever being overwhelmed by force of numbers or violence. What it was the SIA failed in their duty to safeguard and protect. And that's my understanding of it. But of course, this is a new application de novo. We can't really relitigate what happened in the past because those parties are not in the room and they have nothing to do with this. I would point out, sir, that actually bricks and mortar of the building, you know, Flames, Munchies as was, it commits no offence. It is the same location, but actually the same location operating under a new operator, operating correctly. With new staff and new SIA, these problems should not be replicated in my submission, sir.
Thank you.
Can I just jump in? I forgot to also add, Mo is also CIA door license security, so he will also be available when needed as well.
That's great. Obviously, you can't be SIA in an SIA role and also working at the premises at the same time. You can't double tap. But that overview and that understanding of SIA responsibilities is very useful. So thank you for that, Vicky. Thank you.
Councillor Hamlin, have you anything you want?
Nothing new. No.
Nothing new, right. Mr. Clarify.
I'm just if I have a moment, Chair, I'm just checking a couple of things from my notes. Apologies, it's a very detailed submission from Mr. Sem. I'm just trying to catch up with it a bit and make sure I've got everything down. I just note you made an FOI request to the police. What information were you requesting from the police? And were you
yeah, that's a brilliant question. Well done. What I was after was a history of all crime and disorder associated with that premises. You'll be aware that I don't be derogatory about the place because I love it, but you know, it's a sort of hen and stag, the nighttime economy, sort of nightclubby, where everybody goes at the end of the night. That's why the late night refreshment operators are down there. And I spent a lot of time looking at the Home Office data. I couldn't see a reduction in. I couldn't see a reduction in incidents. It looks fairly business as usual. I even went to look at the bid data, which shows footfall of people's mobile phones in the street. Again, that was inconclusive. It was PC Wall said it. He's not here to justify why he said it, and so we are where we are with that. The specifics of the FOI was going back quite a. I mean, I asked for 5 years. I thought 10 to 2013 was excessive. So I did it 5 years, and I fired that FOI in to PC Wall, licensing Hereford. I think I sent it into the Harm Hub at Malvern, who I understood were now taking over the licensing function. But obviously, Kirsty Norris up there, she's in Bridgnorth, and it fell on her desk. But this is all part of the. But the FOI team have said that they've received it too late, and I'm going to have to wait for about another 21 days before that date is ever served back on me, sir.
Thank you for that. I'm just wondering if the licensing officers can clarify any issue of the history of the premises in terms of disturbance.
Yes, thank you. I may have heard incorrectly, but I believe Mr. Semper said there had been no problems prior to December 23. However, I'd just like to make the committee aware that in May 2018, there was one person found to be working at the premises who is in the UK illegally. The licence was up for review and was suspended for 1 month. In July 17, December 17 and September 19, the licensing authority wrote to the then premise licence holder regarding a breach of conditions over door staff. And in September 22, the Licensing Authority again wrote to the current premise licence holder regarding the premise being open while suspended, and also gave advice on the SIA door staff condition. So there has been problems prior to December 23. And I'd also like to make the committee aware that Marmaris does have a licence until 1:30 in the morning, not till 3:30, and a condition on their licence asks for 2 SIA door staff on Friday and Saturday nights from 11 p.m, and when employed externally, they are to wear high vis. Thank you, Chair.
Thank you for clarification.
Okay. No, that's really, really useful. That's fantastic. The FOI, what I was interested in, because this representation was brought on the grounds of crime disorder, i.e. public, disorder, people fighting. I didn't ask about breach of conditions because clearly the police wouldn't know about that. But secondly, I mean, we're talking about incidents 2017 to 2019 or whatever. This is years and years before the applicant came to this city, let alone, applied for a license at this premises. So frankly, the whatever's happened there about illegal workers, with respect, I'd venture to suggest is irrelevant, ma'am.
Anything else, Mr.
Well, just one final point, I suppose. Just to clarify, the police have put through an amended set of conditions. Just wanted your view on that. Because I think there's some elements that you suggested that there may be agreed, but other elements that you disagree with. Just wanted to clarify your submissions on that, if possible.
Yeah, well, you hang on. Stand by. You have me at something of a disadvantage because I haven't got them in front of me, just see if they've landed. Yeah, I've got something from Jennifer. Just looking at my emails now. Please find the conditions.
Would you like some time to consider this?
No, it's okay. We'll go through it because I'm conscious of everybody's time. Right. So we've agreed the conflict resolution within 1 month of employment, which is great because we've already made arrangements around that. Retraining every 6 months. That's a good idea. Training records to be kept on the premises. Superb. And then we've got the 2 alternatives, the 130 and the 330, 2 and 4 door staff. We don't accept that. With respect, we think that 2 is sufficient for such a small operation. And for the reasons I've given, not only the cost, but also the fact there's actually no evidence to the detriment of this gentleman here. And there is evidence of things that went wrong in the past, illegal workers or breach of SIA condition, but actually what we're talking about is the risk of crime disorder there. We've discussed the incidents whereby somebody was kicking the window from outside, the most recent one in July. So, and these were not within licensable hours. Let's have a look. The rest of it looks pretty good. Yeah, the SIA conditions, we object to the numbers, but maintaining a register and having a risk assessment, that's already offered. So, in fact, some of these elements are already within the application before you under para B of section 18. So that's where we're up to. I know we're sort of making it up, not making it up, we're taking it on the hoof, not making up as we're going along, heaven forbid. But that's where I'm up to with that, sir. And Vicky and Mo are nodding away there, so I don't think I've said anything that grinds their gears too much.
Just to clarify, in terms of, I understand that it's the number of SIA door staff you're taking issue at the moment, but just looking at the condition I've received, they'll be employed at the premises on Thursdays, Fridays, Saturdays and Sundays, before Bank Holiday Monday, on Christmas Eve and New Year's Eve, and on the evening preceding all bank holidays from 11 o'clock until the end of licence of activities. Do you take issue with that?
Yeah, the Thursdays not necessary. We get the Fridays and Saturdays, Sunday before bank holidays and bank holidays if we must. But the Thursday, honestly, it's disproportionate in our submission. So there just isn't the evidence to support that you need that amount of SIA element on a Thursday night. It's not a big night out in the city.
And just to clarify, your view on the high-vis reflective jacket?
Yeah, no problems with that. Yeah, good idea. They in the city they tend to wear that rig anyway.
Spriggs.
Yes, please, Chair. I just wondered, could the police just clarify the incidents which led to the review? Am I right in thinking that they were actually on a Thursday night going into a Friday morning? Could you just confirm that for the committee?
Just bear with me. I'll just have a look at the paperwork. Just bear with me. Yes, I do believe they were Thursday night going into Friday. I don't know Hereford personally. Is it a student town?
Not really.
Not. We do have a university here, but it's still in its sort of earlier stages, and there aren't huge numbers of students.
Okay, now coming back on that, I'd say, okay, yeah, so it is a Thursday night going into a Friday morning, right? That's a one-off. That's a one-off, first of all. Secondly, it's Christmas
It's
week.
quite a significant one-off, though, isn't it?
Yeah, look, we are in danger here of relitigating matters that occurred 8 months ago that has absolutely nothing to do with the applicant before you. If he was reapplying for his own license because he'd lost it in previous circumstances and he had something to do with it, well, yeah, that would be a good conversation. But actually, it's got nothing to do with him. Okay, I can't stress that enough. He cannot be held responsible for stuff that had nothing to do with him. And that's about as bold as I can say it, really, without getting frustrated. All right, and that was Christmas week as well. Okay, so there we go. And clearly, we've already accepted SIA on a risk assessed basis. So if you've got Christmas week and it's busy, then the risk assessment will say that we need more SIA. And that incident that happened on the Thursday night into the Friday morning was not a case of the SIA being overwhelmed by crime and disorder and being insufficient element there to control it. That revocation came about because staff fought with a customer. I don't know what the circumstances were, and the SIA did nothing, did not do what the SIA should do. So we're comparing chalk and cheese, frankly, and like I say, I believe that it's irrelevant because it doesn't speak to this applicant who is before you today. So that's my position on that.
Thank you.
May I just make a comment?
Yes, you may.
With regards to this, appreciate it doesn't go to the applicant, but we're not licensing the applicant, we are licensing the premises, and the premises is still of the same business model as it was previously. That will still attract the same people that will cause the same problems previously, and that's where this issue comes from. There's nothing in that license that they've showed how they're going to deal with those problems that will occur again, because it'll be the same people coming to the same type of premises.
Yes, well, we have, with respect, and like I say, I'm not come here for an argument. I'm come here for a debate. Firstly, we've accepted conflict resolution management training, which was your idea, so that is how we're going to deal with it. Secondly, this is a completely new business and a completely new set of staff. So why should any previous angst between members of the public and these staff even exist? Thirdly, this is the epicenter of the city's nighttime economy, and you've already conceded very graciously, might I add, there will always be an element of what have you. And fourthly, what we've offered is the 2 SIA after midnight until terminal hours, which has been sufficient from 2013 to 2020 till February, not to result in any other reviews or significant issues apart from illegal workers and breach of SIA conditions, in as much as the badge was the wrong way round and things like that. So and again, what happened before is not, it cannot be held to the detriment of this applicant.
Are the SIA officers trained in conflict resolution? And if not, why not?
They will
Yes, of
be.
course. Sorry, that
Yeah.
is a very good question. Yeah, the SIA course is about, I think it's about 5 days long, certainly. We provided a conflict, the licensing guys, we've provided a conflict resolution management element of that in the past. We trained the Golden Galleon, for example, and other operators, like night operators down there. And within that package of training is an awful lot of conflict resolution management, along with safeguarding, vulnerability, violence against women and girls. Ask Angela, ask Clive, all that sort of stuff. It's a complete wraparound question. So that's a good point, and thank you for raising it. Thank you, sir.
Yeah, as a consequence then, how could you justify that two members of staff there could cope when they have been shown not to have coped previously? Is there no comeback on them for failing to act when you think they should have? Is 3 or 4 the best answer? I think we've got a bit of conflict here. We need to discuss more. Maybe we'll do that after we've adjourned, but I think that's an important area.
That's a really good question. Okay, and again, I come back to the point I'm making, that the previous revocation, although one part of my argument is that it cannot be held to the detriment of this applicant, but secondly, that revocation came about as a result of the SIA failing to act, as opposed to them being overwhelmed by violence at that premises. They had a duty to act and they failed to act. And the security, the industry, they have their own regulatory body, and whoever the SIA was on duty that night who failed in their duty would have been subject to disciplinary corrective action under the SIA, sir. So that's a comeback on failing to act properly as the SIA. Okay.
Thank you all very much for your submissions. We will now adjourn to discuss our recommendation. It's now 12 o'clock. Could you come back at 12:30? Right, thank you. Right. Thank you all. My apologies for the delay in coming back, but as you can appreciate, it was quite a difficult decision to make, and we wanted to make sure we got it all right. This is a decision. The subcommittee's decision in respect of the application for a premises licence is as follows. The premises licence shall be granted with the following conditions placed on the premises licence, which are based on the representations made by the police and the evidence presented to the subcommittee. Number one, all staff employed at the premises, whether paid or voluntary, are to be trained in conflict resolution within 1 month of commencing employment at the premises. All trained staff will be retrained every 6 months. Training records shall be kept at the premises and produced to any authorised person as defined by Section 13 of the Licensing Act 2003 on demand. The premises licence holder will ensure that a minimum of 2 SIA registered door supervisors will be employed at the premises on Thursdays, Fridays, Saturdays, Sundays before a bank holiday Monday, on Christmas Eve and New Year's Eve, and on the evenings preceding all other bank holidays from 2300 hours to the end of licensable activities at 03:30 a.m. When employed externally, door staff shall wear high-vis reflective jackets or vests. When employed internally, they shall be readily identifiable as door staff. At all other times, the premises licence holder or a person nominated by them in writing for the purpose will employ SIA door staff on a risk-assessed basis. The risk assessment shall be in writing and shall be made immediately available on request to an authorised person as defined by Section 13 of the Licensing Act 2003 or the police. The premises licence holder or DPS or a person nominated by them in writing for the purpose shall maintain a register of door supervisors which shall be kept on the premises showing the names and addresses of the door supervisors, their badge numbers, and shall be signed by the door supervisors as they commence and conclude duty. The register shall be made available on demand by inspection by an authorised person as defined by Section 13 of the Licensing Act 2003 or the police or an authorised officer of the SIA. The reasons for our decision are as follows. The subcommittee has taken into account the detailed written representations and information presented to the hearing by the Senior Licensing Officer, Emma Bowell, PC Norris, Mr Semper on behalf of the applicant Flames, and from Mr Mohammed Gabaj. The committee has fully considered all the relevant paperwork, including policy and guidance. The subcommittee fully recognises the concerns raised by West Mercia Police and the reasons why the representations were made and the concerns relating to the history of crime and disorder associated with these premises, the employment of suitable door staff and the recent revocation of the licence in February 2024. The committee has carefully considered the evidence presented by the police during the hearing, including the supplemental documentation and proposed conditions. The committee has listened carefully to the representations and information supplied by Mr Semper and Mr Gabaj. In particular, the committee notes the history and explanation of the incidents provided by Mr Semper and the information he has provided regarding the crime and disorder associated with the premises and the area in which the premises is situated more generally. However, it is noted that this is a new applicant with no history of operating at these premises. The committee have had to weigh up the evidence very carefully and balance the history of the premises and the fact that this is a new applicant not connected with the past operation of the business. The committee considered whether the number of SIA door staff proposed in the application, being 2, is sufficient to promote the licensing objectives, or whether the number of SIA door staff needs to be increased to 3 or 4. The committee consider, based on the evidence presented to them and the strengthened conditions of the licence, that 2 SIA registered door staff on the days and at the times outlined above will promote the licensing objectives and will be proportionate. The committee has taken all the facts into consideration, particularly the serious nature of the incidents that have occurred, the recent revocation and the operation of the previous licence conditions. The committee have also paid serious consideration to the fact that this is a new applicant not connected with the previous history of the premises. The committee considers that the additional conditions outlined above strengthen the promotion of the licensing objectives and are proportionate. The committee also notes that should there be further incidents of crime and disorder at these premises, this licence can be reviewed. Appeal information. Under Schedule 5, Paragraph 2 of the Licensing Act 2003, the applicant or a person who made relevant representations may appeal against a decision. Schedule 5, Paragraph 9 states that such an appeal must be made to the Magistrates' Court within a period of 21 days from the date that the applicant is notified in writing of the decision. Should you wish to appeal this decision, then it is recommended that you obtain your own legal advice or contact the Magistrates' Court at Bath Street, Hereford. Thank you all very much for your attendance, and I now close the meeting at 1:55. Thank you.